my colleagues for abiding by the 7-minute rule. Before I call on Senator Lee, I want everybody to plan on our first break would be about 11:50, and that would be 30 minutes for lunch. Senator Lee.
Thank you, Mr. Chairman. Thank you, Ms. Bondi, for being here today. I, too, share the assessment that Gail Slater is great. Had a great meeting with her yesterday. Just thrilled that you're here and that you're willing to serve. I'd like to talk to you as a longtime lawyer and one who has handled a variety of criminal matters about the Fourth Amendment. What can you tell us about the Fourth Amendment's warrant requirement and why it's so important?
Well, the warrant requirement is so important, which I've dealt with that since I was in my 20s as a state prosecutor. A warrant is so important because it protects citizens' rights, and that's why it's so important.
And it does that specifically because under the Fourth Amendment, you're required to go to a judge, and you're required to show a judge evidence providing probable cause, and based on that probable cause, you can describe with particularity the things or persons to be searched or seized. And on that basis, the judge may issue or not issue the warrant, but without it, you can't get it. Now, this is time-consuming, no doubt, right?
Oh, I've done many of them, yes. It's very time-consuming, Senator.
And there's probably not a law enforcement officer anywhere in the world who wouldn't acknowledge that they could save time if they didn't have to go about it. And yet we require it. Why is that so important that we do it?
Well, it's so important for the reasons you just laid out. When I said I've done many of them, I've approved them and not approved them as a state prosecutor, because law enforcement, there are checks and balances, and law enforcement must bring these warrants to prosecutors to see if there is sufficient evidence. Then after that's done, they have to take them to a judge to have a judge sign them. So there have to be sufficient checks and balances throughout our system.
So even after you as Attorney General, as the chief law enforcement officer and prosecutorial authority in the state of Florida approved it within your office, you still had to go to the judge. And if it was late at night, early in the morning, didn't matter when, you had to find a judge.
All hours of the night. That was more when I was a state prosecutor. As Attorney General, the Office of the Statewide Prosecutor, Nick Cox, would have done that many, many times at all hours throughout the night and woken up many, many judges throughout the state of Florida.
Is there an exception to the warrant requirement that exists anytime it would be inconvenient for prosecutors or anytime national security might be involved?
I'm not certain about national security, but absolutely no for a state prosecutor.
Right. Yeah, there's
no exception.
There's no catch-all exception that just says this is important or it would be inconvenient for the prosecutor, and with good reason.
Right.
We've learned through sad experience over many hundreds of years, not only in our own country, but also in that of our mother country, what happens when you don't have this in the loop. So you've been asked today a little bit about Section 702 of the Foreign Intelligence Surveillance Act, also known as FISA. There are those who have repeatedly assured members of this committee, including myself, that don't worry, content of phone calls or electronic communications involving American citizens, sometimes resulting in the quote-unquote incidental collection of American citizens' private conversations. Don't worry, their Fourth Amendment rights are just fine. And yet, when they incidentally collect the communications of American citizens, either because they're perhaps unwittingly talking to somebody who might be an agent of a foreign power and themselves under 702 surveillance, they get onto this big database. And at times, there are those in the government, including the Federal Bureau of Investigation, who have gotten into that database and done so, of course, without a warrant because there currently is no warrant requirement. This has the effect of what we call a de facto backdoor warrantless search. Would you agree with me that that is potentially concerning anytime an American citizen's private conversations are intercepted, stored, whether as an incidental collection or otherwise, they ought not be searched without some kind of probable cause showing? I assume you'd agree with me on that.
Yes.
Yeah, it's important. Sometimes people will defend that by saying national security is involved, as if that's the beginning and the end of the inquiry. That has never been the case, and I hope and pray it never will be the case, because that's not what the Fourth Amendment says, not what it does, not what it ever can be. So it's my sincere hope that the next time FISA 702 comes up for reauthorization, Congress finally do what it has been avoiding for a long time, which is to ensure that this doesn't happen. We've heard again and again from people who, if you're confirmed to this position, will soon be your predecessors, prior occupants of the position to which you've been nominated and to which Mr. Patel has been nominated. Don't worry, we have good people. Don't worry, we have good systems in place. Don't worry, it's as good as a warrant requirement, the internal approval procedure that we have within our system. And yet we've found out time and time again that this has happened by some accounts hundreds of thousands of times. These things have been accessed where searches for an American citizen's private communications that have been intercepted and stored through incidental collection have been searched without those safeguards being met, including instances where people just wanted to check on, to cite one example, whether his father was cheating on his mother, or in other instances, doing background checks on someone looking to lease an apartment that he owned and was looking to rent out. This is unacceptable, and we've got to fix it. Speaking of unacceptable, we have seen over the last few years the weaponization of government, specifically within the Department of Justice, against law-abiding Americans. Law-abiding Americans whose offense was something along the lines of, them exercising their constitutional rights, ranging from Catholics attempting to practice their faith, to parents showing up to school board meetings, to people showing up to engage in peaceful protesting outside of abortion clinics. As Attorney General, how will you prevent the weaponization of the Department of Justice against Americans?
And Senator, you just gave the classic example of what's been happening regarding the weaponization. Going after parents at a school board meeting has got to stop. For practicing your religion, sending informants into Catholic churches must stop.
What about branding parents as domestic terrorists or trying to incarcerate one's political opponent as a sitting president of the United States?
Will stop, must stop. Your Senator.
It is exactly the sort of answer I was hoping and expecting to receive from you, and I look forward to doing everything I can to help get you confirmed. I've been pleased with your answers thus far. I've enjoyed knowing you, considering you a friend for many years, and look forward to the great things you will do as Attorney General of the United States. You have my emphatic support and my vote.
Thank you, Senator.
Senator Coons.
Thank you, Mr. Chairman.